to this wonderful conference, Indo-US Legal Sector, Redefining Relationships. I would like to thank Mr. Randir Jaiswal, Dr. Varun Jeff, Mr. Manish Kuladi, and Mr. Rakesh Kumar Sharma for their efforts in conceptualizing, planning, and executing this conference in such a short span of time. During the course of the conference, we will have a virtual address on the future of Indo-US trade and 3 engaging panel discussion on different topics. I will now request Mr. Randir Jaiswal, the Consul General of India, to begin the proceedings of this conference by sharing his words of wisdom, and after that, lighting of the lamp. So.
Good morning, ladies and gentlemen. A very warm welcome to all of you to our consulate. I would like to thank Mr. Rakesh Sharma and the Services Export Promotion Council of India for coming together with us for this conversation. All of you here know the immediate reason as to why we've gathered here. India, or the Bar Council of India, had recently liberalized legal services operations in India for foreign entities. There are, of course, some regulatory frameworks for you to deal with. On that, I'm sure, in the conversation that would follow, our participants, our friends here would know what exactly lies in store for them. But there's also larger context as to why we are meeting here. And that larger context was very evident when a Prime Minister paid a historic state visit to the United States on 22nd of June. President Biden and Prime Minister Modi, in unison, made it very clear that India-US partnership is going to be the most consequential one, or most consequential strategic partnership, which is going to shape the contours, the agenda of the 21st century. The outcomes, if you look at in terms of what we've transacted as defense partners, as technology partners, as partners for critical minerals, as partners for emerging and critical technologies for space exploration, I would urge all of you to take out time and go through the joint statement, because that is where the sum and substance of the visit is, apart from all the atmospherics and all the courtesies that we saw live for those 2-3 days. India joined the Artemis Accord, which means that we are now with the United States together holding hands to explore space for, outer space for the benefit of humanity at large. On the trade side, we want to begin anew, so we put aside all the trade disputes that we have, so that we can strengthen our partnership, bilaterally speaking, in the framework of IPEF, IPEF, and in the framework of Quad and more. On technology side, on knowledge economy, on digital economy, on e-commerce, a lot is going to happen. A lot is already happening. But as Prime Minister said in his address at the joint session, and by the way, he's the only third leader since 1874 in the history of the United States to address the US Congress the second time. I understand it was Winston Churchill, perhaps President Mandela, and Prime Minister Modi. So it was a real honor for us and all of you who are part of this very meaningful friendship, partnership that we established with this great country and great democracy. So as India moves ahead on its economic path to become the third largest economy in absolute terms, while we are transacting a lot with the United States, I see double downing on our economic engagement, on our technology engagement, on our collaboration in various forms. And if that happens, all of you sitting here have a very important role to play, because we are democratic societies, very strong democratic societies who believe in the rule of law. And when you talk of rule of law and transacting business, obviously we seek your support and all that we can do. And there is another reason why we're having this conversation. India, the government of India is committed to reforms. In the last 7-8 years, you've seen a slew of path-breaking reforms having been undertaken. The legal services opening is also part and parcel of that reform agenda. Going ahead, from now to 2030 and beyond, you will see many of these reforms unfolding in India. So it's an exciting time for us. Let's do our best for the peace, prosperity, not just of our people, but for the world at large. So that is my message, even though we were sitting here in New York in this room, in this hall, but the kind of work that we are going to transact will have an impact globally speaking. So with that, I welcome all of you once again and look forward to your support and cooperation. The consulate remains at your disposal to do our best to propel India-US partnership to a higher orbit as agreed by the two leaders. So thank you very much. Ms. Sharma, I'm really delighted that we have this conversation. Each time there is something on the economic agenda or technology agenda, I get really fired. So I'm truly delighted that we've had this opportunity to engage with all of you. Thank you very much, and a very warm welcome to all of you.
Sir, may I request you once again to just come forward and light the lamp. I also request Mr. Rakesh Sharma to join Mr. Randhir Jaiswal and Mr. Manish Kuladi to join him in lighting the lamp. Thank you, Mr. Jaiswal, Mr. Sharma, and Mr. Kuladi. We will now start with our first session of the day, which is a virtual address by Mr. Sunil Talati, Chairman, Service Export Promotion Council. He's on mute.
Mr. Rakesh Sharma, representing the legal sector in our Service Export Promotion Council, other legal luminaries, invitees, participants, ladies and gentlemen. It's indeed a great pleasure and honor for me to involve and participate myself in this wonderful event of redefining the relations between India and USA, particularly keeping in mind the exchange of services. Let me be very honest and clear that I am not focusing only on the export of services of legal sector from USA to India, or for that matter from India to USA, but increased relationship and increased export of services from India world over. Ladies and gentlemen, you'll be surprised for that all these 70 plus years in India, the merchandise export used to be 70 to 75% of the total exports of India. But service export has taken over since last 1 decade. And as of now, service export is almost 45% of the total export. And we shall be very happy, and you should not be surprised to see that by end of 25, the service export will be more than the export of merchandise and goods. That is the focus, that is the thrust, and that is the intention of our Honorable Prime Minister, that we should provide maximum services outside India. And therefore, let me tell you why Ministry of Commerce has done and have incorporated more than 25 export commissions. But Service Export Promotion Council is the only council for the purpose of addressing various issues, matters, and efforts of increasing service outside India. SEPC, that is Service Export Promotion Council, is now 16 years old. And every single export of services from India is covered under its umbrella. But there are 12 champion sectors. And these 12 champion sectors are focused maximum by the government of India and of course by the citizens. And they are export of services in tourism, in hotel industry, medical tourism, accounting and auditing, legal sections, engineering sections, printing and publicity, education, medical health, and number of such other important sectors where there is a tremendous potential of exporting services from India outside. And as you all know, India as of now is a world leader in providing IT services. And IT, information technology and software services are highest in the world. And even in element of service export, IT export plays a very major role. But other than IT exports, India is very much focused on 4 important aspects. One is hotel and tourism. Second is medical tourism. Third is accounting and auditing. And fourth is legal. And let me address you at these 4 in particular, besides engineering, education, printing, and other technological services. But so far as India is concerned, Honorable Minister, last time when he went to UK and in other countries, and this time in USA, which was a historical visit, as Honorable Consulate General mentioned, not only the state dinner is offered, but the manner and method in which our Honorable Prime Minister was received and treated, and thumping, overwhelming reception was given, shows the close ties between USA and India. And therefore, we are thriving that maximum non-resident Indians as well as all Americans, please do visit India. It's a wonderful country, 27 states. Every state has different food, different culture, different people, different dress, and different places to visit. From historical places, from temples and mosques, to sightseeing, to lakes, sea, snow, and whatnot. And therefore, government is tremendously focusing, and we also at service sector wants maximum world tourists to visit India. India is now a safe place. There are no riots, no communal disturbances. People are very peaceful, and all our people involved in tourism industries are welcoming our guest as Atithi Devo Bhava, meaning thereby we are treating our guest as our God. So you will be receiving a tremendous warm welcome in India. Second is medical tourism. Medical tourism is also growing in a very big way. Indian doctors are none to second. They are the world best. And you are all aware how many Indian doctors are there in USA providing services in various hospitals and private clinics and polyclinics and private hospitals, particularly for dental treatment, particularly for fractures and bone treatments. India is considered to be the world leader. And therefore, though far, I would say that though we have not many patients coming from nearby areas, Asian countries, Middle East countries, we want to see that American patients also have the benefit of the best treatment from India at a very affordable and reasonable price. The third important is with regard to accounting and auditing. As you all know, account is everywhere same. Debit what comes in, credit what goes out. Accounting principles are same. Accounting standards are same because we all are adopted IFRS, International Financial Reporting Standard. So world over, published balance sheets are seen and read in the same manner. And we in India, we have 4 lakh plus chartered accountants. I was the president of Institute of Chartered Accountants of India. And we know in how many countries our Indian chartered accountants are working and serving. More than 10% of our total chartered accountants have settled down outside India and are doing excellent. Now a time has come that working and preparation of accounts and then getting them audited so as to make a proper readable financial statements. It is very important to get the services of accountants and auditors, or say chartered accountants. You call them CPA or CA. And we in India do that services at an extremely affordable price, at an extremely fast speed, with 100% accuracy, confidentiality and perfectness. And you will be surprised to know that accounting and auditing services has gained 3 times in last 4 years period. And we expect it to be doubled in next 2 years' time. There is a demand of Indian chartered accountants. Same way, the fourth important is with regard to the legal section. Though there are WTO compulsions, WTO requirements, chapters are there, Indian Bar Council have decided that yes, let foreign legal firms come to India. To start with, they may not be allowed to argue out in the courts, but all other services for which Rakesh ji will be giving you the details can be made available to Indians and vice versa. Our Indian lawyers, Indian legal luminaries are extremely hardworking. Maybe yes, I don't mind accepting and without any hesitation that when it comes to English drafting of an agreement or a petition or even a joint venture agreement, English lawyers and USA lawyers do it much better so far as the presentation of English and conditions and other clauses and sub-clauses are mentioned. But when it comes to minutest or the minor details of the agreement with regard to taking care of both the sides, legal lawyers from India don't miss a single point. So it will be a fantastic combination if there are mutual recognition between these two countries on legal section. We provide services to USA and in turn we get the expert and advice, benefit and drafting skills from USA lawyers to India. I see a very great future. Our Honorable Prime Minister also has mentioned that will be reaching 5 trillion economy very soon. We are completing 75 years. It is Amrut Mahotsav going on. G20 is being celebrated. World over people are coming, and when they see the new India, the new roads, the new trains, new airports, they're really amazed that in just 10 last years, what a great improvisation has been there and development in infrastructure and other services. So my humble and most cordial invitation to all of you to please come to India and visit India. And then have full focus on export, exchange of services in legal section, as well as in accounting and auditing sections, and other 12 important champion sectors, for which I shall be circulating a detailed brochure through Advocate Mr. Rakesh Sharma to all of you, all participants and other in USA. So friend, it's indeed great pleasure to be with you, to be a part of this wonderful efforts made by Rakesh Sharma ji to bring two great luminaries on the profession together to see how best we take advantage and benefit of each other, increase the export of services from India, as also we don't mind importing services from USA and see that we provide best of the legal services to our clients at the most affordable price and at the same time at the best quality. I wish this function and the conference a grand success, not only for the 2 days function, but its results and future developments by showing the actual results of genuine increase in export of services, of legal department, of legal advisors from both the countries. Wish you all the best and thank you so much for the invitation. Thank you.
Thank you, Mr. Talati, for your insightful comments on the future of Indo-US trade. We will now start with our first panel discussion of the day, US law firms in India, growth and challenges. And for this, I will invite Mr. Rakesh Kumar Sharma, Chairman, Legal Sector, CGC, Service Export Promotion Council, Mr. Joseph Rosenbaum, Partner, Rimon PC, Mr. J.G. Safer, Partner, Dunnington, Bartholomew and Miller, LLP. Please come on stage.
Good morning, and thank you very much to the Consulate for supporting, hosting, organizing this event. In fact, I am enclosed by two wonderful legal luminaries with me, Mr. Joe and Mr. Safer. So before proceeding ahead, I would love to see that if they can tell just a short about themselves, so that probably will be definitely highlighted, enlightened by the experience, expertise they have before we go over to the topics. So let me request Mr. Joe and Mr. J. Yes, Mr. Joe, please.
First of all, I'd like to thank the Honorable Mr. Jaiswal and the members of the... Okay, we'll try again. I'd like to thank Mr. Jaiswal and the staff of the Indian Consulate here in New York, Rakesh Sharma, old friend and colleague, Jay, for joining us here today. My name is Joe Rosenbaum. I started my legal career as a lawyer, international lawyer at American Express, and having set up operating centers for American Express in Madras. And after that, did a significant amount of outsourcing work for banking and financial institutions in the United States to companies in India over the years, which this is not a plug, but it led me to write a book about outsourcing and legal issues that related to contracts and outsourcing. And over the years, I've been an international lawyer probably since my days at American Express. Right now I'm at a law firm that has a international footprint. Still do a lot of work internationally, some of which is in India, and it is an honor and a privilege to be here today. Okay.
Hello, everybody. I'm Jay Safer, and my regards to Consulate General and to having us here at the Consulate. I would also like to thank Rakesh and Danish, who is someone I've known at Draft and Craft for years. And of course, I have the honor of now meeting Joseph Rosenbaum. I am a partner at Dunnington, Bartholow and Miller in New York City. I am, just to tell you a little bit about myself, I am a litigator. I'm an arbitrator, both in terms of being an advocate and as an arbitrator for international under the ICDR and AAA on the roster of neutrals, and have handled a number of arbitrations and had a number of litigations involving clients internationally and including India. I've had a long relationship with India as a lawyer. I had the good fortune for a number of years and still do, representing the State Bank of India and related entities. And I got to know India through them. I even participated in the Indian Day Parade, which is, as many of you know, is held in New York City. I'm also an adjunct professor and lecturer at law at Columbia and Fordham, teaching foreign lawyers about the American legal system and helping them get their LLM. I got to know particularly the subject we're going to talk about today because two reasons. One, Rakesh and Danis came to talk to me about what could be the role of arbitration in creating an international arbitration center in India, which is, as you may know or you'll learn, is one of the topics. And the other thing is they were kind enough to ask me to do a worldwide webinar in the last couple months on this very subject of American lawyers opening up offices, working in India, and as you're going to hear from Rakesh and Joe and myself, we hope we can help you learn what has taken place so dramatically and what can and hopefully will take place dramatically in India as Indian lawyers hopefully feel comfortable about the fact that non-Indian lawyers will eventually be opening their offices and working in India like they do in so many other countries in Asia. So with that, thank you again for inviting me to speak. It's really a pleasure to be here. Rakesh, would you like to start, or Joe?
Yes, please. I think let's start with the topic, and I think Mr. Joe will start with it, because I understand probably opening the legal sector for the US law firms or the US lawyers, it's been long awaited from both the sides, Indian as well as US. Both the sides have been long waiting for this opportunity, because this is going to step in as a strong bond between both the sectors, both the places here. And let me request Mr. Joe to start with it, please.
Thank you. So it's helpful to understand the historical perspective of both U.S. and Indian law and the relationships between law firms and the legal systems. So without kind of belaboring these, the United States legal system was derived again from British common law. When the U.S. declared independence from England in 1776, they adopted a common law standard. That being said, litigation tends to be adversarial. Lawyers do battle in court against each other, with the judge being an impartial, or the judge and the jury being an impartial, presumably trier of fact and law. The U.S. has responded. The legal system also responds to changing economic, social conditions. So the civil rights movement led to laws prohibiting racial and religious discrimination, and the women's movement led to laws against discrimination against sex. In India, there is a common law tradition which was introduced by the British, but there is a very strong influence from Buddhism, Islam, and Muslim. There is a unitary court system, which, unlike the U.S., is divided between federal and individual state courts. In India, judges can actively investigate cases and will question witnesses and lawyers on issues. But the Indian legal system has also responded to changing social and economic conditions. Some of the independence movements created liberalization of the economy, and certainly some more recent Hindu nationalist movement has led to a greater influence of the Hindu values being embedded in Indian law. And so, despite their origins and history and approaches and culture, which may be different, they both have some remarkable similarities as amazingly democratic countries. There's a written constitution that defines the rights of government and citizens. There's a system of courts that interprets laws and resolves disputes. There's a system that decides criminal cases. But more importantly, there's a commitment to the rule of law and the protection of individual rights, and the basic principle that no one is above the law, that everyone, including the government, is subject to the laws of the land. And these are important values that both U.S. and Indian culture and systems share. So why did India prohibit U.S. lawyers or foreign lawyers generally, from being active in the legal system in India? Well, as a matter of law, there is an international law of comity, which is basically the rule of reciprocity, which is codified in India in the Reciprocity Act of 1943. And what it does is it allows the government to prohibit the practice of professions, among other things, from countries that do not allow reciprocal rights for those professionals in their country. And in the U.S., any Indian citizen could apply to become a member of the bar here in the United States. They would have to apply within the state. They'd have to pass all of the written exams and the qualifications and ultimately be licensed. and that was not considered to be quote, reciprocal at the time. In 2016, the Advocates Act, which did prohibit originally, was amended to allow foreign lawyers to practice law on a reciprocal basis. And in 2018, the Supreme Court of India ruled that there was no permission, there was no adoption of any legislation or rules that would allow foreign lawyers or foreign law firms to practice in India, whether it's whether it's litigation or non-litigation.
Oh, thank you. First, let me thank Joe, who did the bulk of the work on these slides, and then Rakesh added an important slide, as you'll see later, and I was able to add some information to his good work. Let me go back a second just to make sure something most of you are aware of, comparing the two legal systems. As you know, in the United States, we have judges and juries for both civil and criminal cases. The judges in the United States, as most of you know, we have a federal and state court system. In the federal court system here in the U.S., federal judges, district court judges, Court of Appeals judges, Supreme Court justices are appointed by the President with the consent of the U.S. Senate, working together to try to make, if they can, at least in the past, judges that would be federal judges. But federal courts in the United States, as you may know, have a limited subject matter jurisdiction. So that unless you have diversity on both sides or you have a federal question, you cannot get into federal court. But if you do get into federal court on diversity, you have a threshold of $75,000, and federal judges are appointed for life, and they hear criminal and civil cases. In the state courts of New York, judges are appointed many different ways. There are appointments by election for Supreme Court justices. There are elections for civil court judge. There are appointments to family court judges, to housing court, and they are appointed for terms. So you have different types of judges being appointed in the New York State courts. Plus, you have a commercial division, which is a business court in New York State. And think about this when we talk about the, as Joe said, the Indian courts, and we're going to compare lawyers in both courts. But in the commercial division, for example, in New York State, the threshold varies, but in New York it's $500,000. But it's a total business court, and they only hear civil courts. The other thing about New York State courts, in New York and federal practice, which some of you may know, is the discovery in the New York States covers a wide range, expansive area. Now, in the Indian courts, of course, you have a quality of judges that is unique. As I will point out later, I had the good fortune of being asked by George Washington University Law School to go to India and do a program in which I argued a case in front of high court judges and a U.S. judge, and a group of Indian lawyers argued the same case. You can imagine how fascinating that was for me to be able to go there and engage in this program. So I've had the good fortune of actually meeting and getting to know, at the time, high court judges, which was really an honor for me. And finally, again, I want to know that my relationship with Danish and Rakesh and Draft and Craft, I even had the honor in the United States of being asked to light the lamp at a meeting. That was truly unique, and I can't tell you what a joy that was for me. But as Joe was saying, think about the differences in this, and yet the closeness in terms of values that the U.S. courts have in the Indian legal system. And as he went through what we share, that's very important. So when we talk about how should U.S. lawyers think about coming to India, as Joe will explain first, and then I'll follow up on what are the rules now. How should Indian lawyers react to this? should they view this as a frankly, a threat? Or should they view it as an opportunity in the future to make a relationship that works for both? So Joe, do you want to continue now?
Yeah.
Oh, Rakesh, I'm sorry.
Rakesh is going to talk a little bit more about Advocates Act.
Okay.
I'll try to introduce all my friends to how the legal system of India is working. Indian legal system started with the court culture. So initially we used to have the courts divided in civil and the criminal cases. Subsequent thereto, we started recognizing the importance of the technological or technical members into different parts. So we started carving out different tribunals. Today we have more than 20 tribunals in India dealing with service matters, custom matters, and of course couple of others. Then two more changes occurred. One, we started shifting towards the arbitration. Second is the mediation. So these two changes are also being absorbed very quickly by the Indian legal system. Now, what is the genesis of the entire Indian legal system is the Advocate Act. The Advocate Act clearly, very vividly explains what is an advocate, what is their strength, what are their ethics, what are their liabilities, and how can they work upon. So I have just carved out few relevant sections of the Advocate Act which can probably connect with the topics we are now talking about. So it says that if we talk about that, what is the structure of the councils we have? We have a Bar Council of India which supervises all the state councils and actually dominates them. Every state has got a state bar council, just like we have in US. So every state bar council has to recognize the people who are eligible to practice as an advocate. So that's what has been defined and explained in section 6, that what are the functions of the state bar councils. They have to recognize a person as an advocate. And then we have section 24, which says that what are the requisites when we talk about a person becoming an advocate. So the primary part which comes over here is that we recognize only those as an advocate in India who are the citizens of India. So that's what section 24 postulates initially. Then we have that right to practice given to the advocates under section 30. And if we switch over to section 33, it says that only advocates can practice in India. So section 30 and 33 are to be read together. And then we have section 32. Now this is an exception very beautifully carved into the Advocate Act. It says that if in a scenario, a court wants that somebody other than advocate can also represent a case, so the court can grant that permission to any individual, any person to represent a case. So section 32 deals with it. Then we have the section 47 which deals with the reciprocity, which we are definitely going to talk about in this topic. Reciprocity leaves something very open by the Advocate Act. It simply says that if Government of India, central government, by any means decides that advocates of a particular foreign country are not to be allowed to practice in India, then that reciprocity comes into play. Otherwise, it's been left open for the bar councils to decide upon. I'll just take a minute's time here. Now, let me also share that when we talk about the advocates, so advocates, I understand that we have already permitted the Indian citizens traveling across other countries, having a degree, a law degree from there, and certain colleges have already been recognized by Bar Council of India. Even there are about 4 colleges which are recognized in US. So their degrees are also as good as having a degree in India as a lawyer. So this is one category. When Bar Council of India came with the rules, all these things were considered, and now Bar Council of India felt that there is a need, that we are living in an age of globalization, It's not an age where we are living in a localization. We are now living where there is a globalization, and when there is a globalization, the people have to travel, they have to represent the interest of their clients, so we have to go beyond these borders. So this is basically, we are trying to understand that how Bar Council of India has tried to carve out space for the foreign lawyers coming to India. I think we'll discuss this ahead in the next slides. Yes, Mr. Joe, please.
So, hang on a minute. So, Jay, you want to talk about the fly out? And then we'll get...
Thank you, Joe. So after the 2018 decision of the court in Bar Association Council of India against A.J. Balaji, the court indicated that it was open to have some kind of non-Indian input into practicing law in India. But after that, and it would look into the rules that might be created, so that what it made clear was that you could now, if not before, have a fly-in and fly-out ability of lawyers in certain situations. But you could only stay a short period of time. Later, under the rules, it became 60 days at a time. You had a limited amount of what you could do for that period of time in representing your foreign clients. Interestingly, arbitrators could be non-Indian lawyers and serve as arbitrators, but lawyers could not come in and represent the parties to the arbitration under the fly-in and fly-out rule. But at least under this new rule, there was an opportunity and certain types of legal advice for non-Indian clients to come to India, as long as you didn't overreach what your responsibilities were, to fly in and fly out for a short period of time. And it really started the creation of a process which continues even under the new rules. So as Joe and Rakesh can go forward, and then I'll add things, the fly-in, fly-out rule was very important. Joe?
Right. So the restrictions previously had been based on a number of important factors in the differences in the legal systems. First of all, obviously, there's a concern that the influx of U.S. lawyers and law firms might cost Indian lawyers jobs. And that is a legitimate and a concern of any nation to protect the economic interest of its citizens. There was also an issue of quality. Indian law firms tend to have an extraordinarily high quality, even smaller firms, and there was some concern, not overly voiced, that the quality might deteriorate with the influx of American lawyers. And last but not least, Indian law firms have a different culture, a different way of handling their clients and communicating with their clients. They also have a much more hierarchical structure in terms of decision-making within the firms, different from many of the U.S. firms. And there was a concern that the influx of U.S. law firms might impair or adversely affect the Indian culture and the relationship between Indian lawyers, not only among themselves, but with their clients. That being said, the relationships between U.S. and Indian law firms has always been extraordinarily strong, even before the bar rules, the new BCI rules were announced. In 2016, there was an India initiative that was launched by the ABA and the BCI dealing with legal education, with research, which exchanges of information between the two nations and their legal systems. Again, all of this intended to begin the process of liberalization, of getting lawyers both in the United States and in India to get to know each other, to get to understand each other, and to get to communicate with each other more robustly. And by 2018, there was a formal legal exchange program which allowed Indian individual citizens, whether lawyers or not, to come to the United States and work in and learn in accredited law schools in the U.S. and gain law degrees, many of which were on scholarships. So that brings us to today and the new bar rules. And in March of 2023, just a few months ago, part of the liberalization efforts that the Honorable Consul General Jaiswal, Mr. Jaiswal, had mentioned earlier, in the legal field, the Bar Council announced that it would now allow U.S. lawyers, foreign lawyers, but as a U.S. lawyer, I'll just refer to the U.S., to practice law in India, both corporate and transactional work, to advise clients on matters that related to international law, and to establish law firms in India. Hire Indian lawyers, and as I think Rakesh will mention, the implications of a U.S. firm hiring an Indian lawyer are also not insignificant. You want to say something about that?
In fact, before we move on, I'll say one thing, that there had been few concerns of the Bar Council, State Bar Council in India, and all those concerns are now being looked into by the Bar Council of India and a larger perspective. And we are expecting more clarifications, more changes coming in the month of July, when actually the registration of the foreign law firms and the lawyers will commence. So when I think, let me just say that it is just a relationship of two bodies or two lawyers from different countries coming together. And there is to be a balance. So the fears of the Indian lawyers had been, as Joe had rightly said, that probably they felt that they may lose something. But the way Bar Council of India is coming up, it's the gain. It's not the pain. So to my understanding, when we say that we are going to transact commercial transactions, the foreign lawyers are not going to litigate in the Indian courts. So we need to understand those gaps. So probably when we say the foreign law firms will be hiring Indian lawyers, so it will be eventually a strength given to the Indian legal sector. Now, those restrictions are to be diligently followed, that how BCI rules are taken in spirits. So this is how I believe it will go on. Yes.
I also would like to point out the BCI has yet to formalize the actual applications and rules, though there are a number of law firms that have expressed an interest already and have for many years expressed an interest in establishing offices in India. India is a tremendous economy, and the relationship between the U.S. and India has always been extraordinarily strong. And so, you know, to say that U.S. law firms, some of the major firms, are eager to kind of get into the marketplace would be an understatement. One thing to understand is, and again, this goes back to the cultural differences and differences of terminology. Under the BCI rules that were recently announced, it says that in order to be admitted to India, to allowed to practice in India as a foreign lawyer, you need to be part of a recognized bar association in the foreign country. The terminology is a bit misleading. In the United States, we refer to the Bar Association as a voluntary collaboration, a membership group, which lawyers may or may not join for the purposes of education, collegiality, collaboration, common interest. But that is not the entity that actually licenses lawyers, that qualifies lawyers, that disciplines lawyers. Each state has individual bar groups, whether or not in New York it's the appellate division of the New York State courts that licenses lawyers. And so when the Indian rules say a recognized bar association and a certificate of good standing, in the United States that would not mean that you're a member of the American Bar Association. It will mean that you have a certificate of good standing from the qualifying licensing authority in the state in which one is admitted to practice. It's also important, as kind of Jay mentioned to me earlier, that lawyers are also admitted not only by state, but also into federal courts separately. You have to apply. So these are some of the things that over time we expect to be clarified in many of the applications and discussions between the BCI and the U.S. and quite frankly, every country around the world that is interested in having foreign lawyers practice in India.
I'll just add something very simple. That BCI rule says that when anybody which regulates the lawyers of a foreign country, so those bodies, be it an association, be it a bar or a state council or anything, so those regulating bodies, they need to give the license, and only those foreign lawyers having those license given by those regulatory bodies become eligible to come under this. Looking into other categories also. I'm sure that Mr. J will be further adding to this. Yes.
Thank you. Why is this being done? As Joe and Rakesh tried to indicate, the rules were actually announced in the Gazette of India, and they were particularly focused on the need for foreign direct investment in India. They wanted to encourage international law to be brought into India, and they wanted to encourage international arbitration. So they said, look, the world has changed. It's a global economy. India has to compete. Apparently, during the pandemic, now India, the law firms particularly, did very well. But once the pandemic changed, there was a concern that other economies in India would have to compete even harder. So they said, we need to do stuff to globalize. After they came out with the rules, there was obviously, as you might expect, a number of issues and law firms. So then what the Bar Council of India did is they came out with a press release 9 days later, and they spelled out exactly, and as Joe and Rakesh were saying, and I'll go through this quickly, but to make sure you again have an understanding of what the Bar Council stated was their view, however, not in expansive language, but to give you an idea of what American law firms have to consider and what Indian law firms, which I'll talk about in a minute, are trying to do to deal with this. First, they said the foreign lawyers and law firms should be allowed to advise their clients about foreign laws and international laws only, not Indian law. They'd render advisory work about such laws for their foreign clients. They don't represent Indian clients. Non-litigation areas only. I couldn't go there and litigate. Joe, with his great transactional ability, could go there and do non-litigation work for his clients. You couldn't be allowed to argue in court or go into court. Very important, they said it has to be on a reciprocal basis, so that when a non-Indian law firm, if they attempt to open an office in India, they have to demonstrate that in their own country, as a foreign country, Indian lawyers have the same reciprocity rights. And the problem with this is a lot of this information is not defined. So what does reciprocity mean? And Indian lawyers have raised that concern. What does reciprocity mean? What about the fact that in some countries it's hard to get in because of visas? Does that mean that there's no reciprocity? Now, the bar councils of the UK and England, UK and Scotland and Wales, they historically have had a certain knowledge of Indian law, and they are trying to proceed and actually signed an MOU with India. You could have Indian lawyers become part of firms. But once they became part of firms, their role was limited as to what they could do at the firm and with respect to Indian clients, which they could not represent, as opposed to foreign clients. International arbitration, the exception. A foreign lawyer can come in and represent in the international arbitration area their clients. Now, I don't know whether Joe wants me to wait, but there are problems with that too. For example, if you're going to have India become an international arbitration center, Singapore is very well known for that. Hong Kong, you have to give people a reason to want to come. So that if there seemed to be an issue whether Indian clients were still only able to have Indian lawyers, would people want to put as a situs an Indian arbitration depending on who could represent them? And remember that an international arbitration center, at least in New York, they don't administer the arbitrations. They're a location where people can come and hold their arbitrations. They're a location where they can put on programs. But there's no reason why India, if everyone works together, can become very important given the great number of trade that goes on, given the billions of dollars that are available in legal work, to become an arbitration center. Again, when you're dealing with the new rules, you have to understand, as Joe said, registration. Registration requires a Form A to be filed. They haven't created the form yet. It requires a fee of $25,000 for an individual lawyer and $50,000 for a law firm, plus a guarantee of another $40,000, and it's only for 5 years, and then you renew for another 6 years. So you can see there are a lot of issues to be decided. And as far as Indian law firms, I was told yesterday that there is an issue whether it will go anywhere seeking to stay the rules. I don't think that's going to happen. There's a society of Indian law firms that have raised a lot of questions as to how this is going to affect them. As Joe indicated, and Rakesh, there are issues where they talk about, well, the culture's different. We don't have contingency fees. We don't have in India the type of marketing that they do. What is it that American law firms will be allowed to do that Indian law firms historically has not? So you can see there are a lot of issues, but they're trying. They're trying. And I would expect that it's going to work out. And so that, for example, they're saying that there will be some American law firms, when they come, try to create joint ventures with Indian law firms or middle-sized Indian law firms. So these are all issues that are going to come up. But I'm hoping that we are able to give you some view of how the rules are stated and the issues to be decided in the future. Joe, Rakesh?
Yes, in fact, I'll take a step back. Jay has very rightly pointed out the things we are missing or the things we have put forth. Now, let me take a step back why these rules were needed. For example, I'll take an example that there is an agreement entered by an Indian company with an American company. Now, there is an arbitration clause. So this arbitration clause, the jurisdiction was never fixed in India simply because the US attorneys could not go to India to present a case, to fight a case for the arbitration on behalf of their US clients. So what was happening? We were having those jurisdictions shifted to other countries. So we as an Indian lawyer were missing this as an opportunity to meet our counterparts of the US industry. So if today after these rules are followed in spirits, there will be an agreement by an Indian company with an American company. The jurisdiction of dispute, if at all it will be there, may be in India or it may be in US. So far reciprocity would mean the same thing, that US attorney may come to India to present or represent their clients. Similarly, if the jurisdiction goes to US, the Indian attorney should have the reciprocity to come to US and represent their clients. So this is one such an example that when globalization is happening, so we need to take things in a larger perspective. So this is just an illustration. So otherwise what was happening, we were having a jurisdiction in a third country. So in that case, the Indian lawyers were not getting a chance or an opportunity to go to that country and represent their client. So the lawyer of that country were actually gaining out of it. So this is what the law, the BC has come out with. This is just an example to explain that what was the need of these rules. Now these rules are going to facilitate. Reciprocity means that what facilities an Indian lawyer gets in US, the US lawyers will get in India. So it's nothing big. And I'm sure that when these rules are formed, there is a friction. So that brings out more smoothness, more clarity on all these issues. I'm sure we are still to move on. Yes, Vijay, please.
Yeah, I just want to add one point which is very important. Relationships are critical. Understanding each other is critical. Whenever I was working, and I've been doing international law for well over 40 years, but especially in India, one of the things that I learned very early in my career was that you always involve local counsel. So even when I was negotiating transactions on behalf of a U.S. client on the other side of an Indian client, whether it was an outsourcing company, whether or not it was a real estate transaction, whether or not it was a financial transaction, one of the things that I learned very quickly is you cannot do it alone, especially in someone else's country. And so so that was what helped me build personal relationships with many Indian lawyers who I've worked with over the years. And the more we know each other, the more we work together, the more we collaborate together, the more we learn about each other. And that's what stimulates a lot of the relationships that allow us to understand. But make no mistake, a U.S. lawyer and a U.S. law firm still needs to work collaboratively with Indian law firms, because it's not a question of whether or not a U.S. law firm can come to India or a U.S. lawyer can come to India and sit down at the table. We will never understand Indian law exactly the same way, or Indian culture the same way, as a local Indian lawyer will. And we have to be respectful of that if we are going to succeed in building stronger bridges between the two countries. So let's take a look quickly at by the way, I take credit for all of these graphics, both good and bad, these crazy little bouncing things. The countries have an enormously growing economy. India is becoming as you know, Mr. Jaswal said, an amazing economic powerhouse. This leads to increasing trade and investments between the two countries, going both ways actually. There are many who believe that competition may be dangerous. There are some who believe that competition will actually increase not only the quality of the legal profession, but will also lead to enhancements for clients. And quite frankly, there is a sense that liberalizing these rules will attract extraordinarily high-quality talent into India, people who want to come to India as a foreign lawyer and enhance the profession. There certainly will be, as there have been building on the current foundation, enhanced cooperation. With any good fortune, we will soon see an international arbitration center in India. And this is just another evidence of the liberalization that continues to take place as the Indian market globalizes and becomes part of a more global community. The U.S. is poised to also be one of the key partners in that relationship. There are also some challenges that still remain, and we've talked about them. There are different systems, and we cannot kind of ignore those differences. Not every Indian lawyer, even though English is spoken in many places in India, not every Indian lawyer is fluent in English, and not every Indian lawyer is knowledgeable in some of the idioms and the phrases and the legal terminology that the U.S. lawyers tend to employ. I mean, I have a quick anecdote. When I was a young lawyer, I was doing a deal in Brazil And as most U.S. lawyers tend to do in contracts, they put things like such determination not to be unreasonably withheld or in good faith or things like that. Whenever there was a decision to be made in the contract, U.S. lawyers tend to write, such determination not to be unreasonably withheld. And it was pointed out to me by a Brazilian lawyer who has long since become a very good friend, that in Brazil, courts don't honor reasonable determinations. You either have the right to decide or you don't, and nobody questions whether or not it's reasonable or not, and so that would be unenforceable. Things like injunctions and those kinds of terminologies don't apply in many places around the world. So language, culture, all of these things need to be building bridges so that we better understand each other. There is a concern that there will be a loss of jobs. My view is that the increased trade and the presence of U.S. law firms in India will actually increase the demand for legal services and create additional jobs. At least that's my hope. And in terms of quality, I think the bar associations or the licensing authorities of each jurisdiction need to maintain a close eye on the fact that we need to kind of consistently maintain the quality of all of the efforts of all of the legal profession to work together. So
I'll just add one thing which is very relevant when we connect back to India. When we talk about the arbitration part, one part is that we fight against getting an award done. So once we have an award, then comes the second stage, the implementation of the award. When we come for the implementation, we have the setup, what we call is the commercial courts in India. So those commercial courts are operating at the district court levels. So because they are operating at district court levels, so I came across a very good law firm in US, and they asked me a wonderful question that they were facing, that in India they had to face two different district courts for the implementation of the awards, where the local languages in one state was Konkan and the other stage was Bangla. So they were trying to understand that how they can go ahead with the things. So that's again a language and the cultural part comes into operation. That's where probably the strength of the Indian lawyers is going to facilitate, understand, and be an important part of the foreign lawyers. Yes, if anything, Mr. Jace.
I mentioned some of the issues that have been raised, particularly by Indian law firms and the Society of Indian Law Firms, as to different rules that they've historically worked under in India, different cultures, who is going to be responsible for the ethics of new lawyers. In many of the countries like Singapore and others, they actually have Indian desks, as you may know, where if they have an Indian law issue, they have lawyers in those countries. But I tend to believe that, as I think you will, that given the globalization of economy, India has a wonderful opportunity, as Joe said, if they can work together so that Indian law firms start to feel comfortable. There are going to have to be questions. For example, if a U.S. law firm takes in Indian lawyers, is going to be some kind of concern by Indian law firms as to those lawyers who go there. But hopefully they will work out these things, because in other countries, they've been able to work it out. And they've been able to coexist either as joint law firms or as separate law firms. There's still going to be certain legal issues under these rules, unless they expand, that Indian law firms will have the only opportunity to represent. But they want to have an international arbitration. They want to have a location where people in their contracts, people who are deciding where to arbitrate. Why do I want to go to India? Because there should be a reason why it's to our advantage to arbitrate in India. The same thing in dealing with any legal issue as to where you go to litigate. India can now take the opportunity to make itself very favorable, very attractive, just like other countries have. And I think we will start to see that, People will have to work together. There's no question about it. People will have to feel comfortable. For example, there was some issue raised by Indian lawyers. Well, look at the rates that are going to be charged to different clients. How do we deal with that? Look how Indian lawyers get compensated. But I think these are true in countries around the world. So that although there are going to be culture differences, language, to some extent, as Joe mentioned, differences, I think if they can provide a business opportunity for Indian law firms and the U.S. law firms, and the U.S. law firms have a reason, which would be, to make money and expand their representation of their own clients to come to India, I think we're going to see, and people are saying, well, it could take 4 or 5 years. Once the registration process gets going, if they can work out the reciprocity concerns, that is a real issue to make sure that Indian lawyers feel there is reciprocity. But to make American law firms, there are numerous American law firms that have already started looking into this. They have started saying, they've gone to India and had meetings to try to say, well, what do we need to do to get our foot in the door? So I think we're going to see that, and hopefully in the next few years, you will see India opening up for foreign law firms to come there, and particularly in international arbitration.
So as we kind of come to the conclusion of our presentation, I was asked by the managing partner of my law firm to kind of present bullet points about how we would approach our relationship with India. And I basically put these 5 things, the first 2 of which were taught me by my first international law professor in law school, and the last 3 by my mother. Do the research, understand the country, the culture, the system, find out where the opportunities are, and kind of become knowledgeable in the country that you are going to become a guest in. Hire local lawyers. Don't pretend that you know it all. Make sure that you enlist local talent who will help you, who will collaborate with you, who will educate you. Be patient, okay? Things don't happen overnight, especially between systems that have been cooperative, but not as intertwined as we hope they will become. So be patient and don't, Americans tend to rush into everything. When I was, I took a job as the General Counsel of American Express in Canada as an expatriate. And the first thing I learned is that things don't move as quickly, even in our neighbor to the north, as they do in the U.S. People actually queue up politely online and wait for things. And if they bump into you, they say, excuse me, they don't stab you. And so be respectful, okay? Understand that their culture, their system has been around a lot longer than ours, to be honest. I mean, we think of ourselves as a strong, independent nation. America has a history that's barely 250 years old. India has a history that goes back thousands of years. So we need to be respectful of these things and understand as we try to enter that market. And be flexible. As both Jay and Rakesh have made points well taken, not all of these rules, not all of these systems have been ironed out or clarified. Some of them will be changed based on questions that arise. Some of them will be adapted to circumstances that change. We can't predict what will happen, so we need to kind of not be inflexible, but understand that we can adapt to these cultures and these changes. So with that,
I'll just request to go back to the previous slide.
please.
I just want to say that I think my mother must have known your mother, Joe, because she told me the same 3 things.
It's actually frightening.
So before going ahead, I think I got to mention few important things over here. That in India, how do we start the relationship? We start relationship by saying namaste. When we say namaste, this means addressing somebody from a distance. And once we just go closer, then we do the handshake. So we are now closer to that. And once we travel a little ahead, we embrace people. So this is how these rules are to be taken up. So maybe they are starting with namaste, we'll move on to the handshake, and for sure, this is going to embrace and last a long-lasting relationship. And the 5 points which my friend has called out, I'll say that these are the 5 fingers of the hands, so they'll make us strengthen it. So if we take care of these 5 points, it's going to strengthen the relationship, have a wonderful bond of legal systems of both the countries.
Well said. Well said. Now we get the slide.
Any questions? Anyone who has got anything more to talk about, anything more to be asked about, please feel free.
I think we've scared them all.
Look like. Yes.
Have any U.S. firms applied yet to be firms in India? Has that happened yet, or is it still too early?
There have been a number of firms that have requested applications from the BCI. The BCI has not yet kind of finalized the forms. That is expected, I think, Jay, you said in July, or Rakesh, July?
It's in July.
Yeah, so they are expecting to kind of formalize the actual application forms and materials next month, in which case you will start to see many firms that will start to apply. I know of at least 5 or 6 that have already expressed an interest and have made inquiries to the BCI about what is necessary for them to apply. So the answer is yes.
And remember, they still have to create Form A for them to do the registration statement, but a number of the major law firms, at least in the U.S., have made announcements that they are looking into this. Quinn Emanuel, for example, the head of their firm, publicly went to India to try to speak to them as to how they could consider coming there. And then you have the well-known international firms, Latham, Baker & McKenzie, White & Case. They all have an interest because remember, once one firm gets in, then the other firms are going to want to compete to go there. It's going to be a process. And again, the reciprocity, and by the way, I didn't get a chance to say it, to become a law firm or a lawyer in India, there are 12 conditions you have to meet, and they're stated. I won't go through them all now, but you do have to have a number of forms filled out. You have to have, as Joe mentioned, this, they talked about from your local, you have to have a certificate of good standing. You have to have declarations from various governmental entities in the U.S. dealing with lawyers. So there are 12 conditions, but they're not conditions that law firms, particularly the major law firms and even individuals, will have that big a problem getting. They just have to get whatever certificates, declarations are needed. And this is to protect India. It's to protect the clients, but they have tried to think out things that would make people feel comfortable that if the U.S. lawyers, non-U.S. lawyers come to India, they will have shown that they have the ability, that they have the background, and that they are able to carry out what the Bar Council would like non-Indian law firms to offer in India.
I want to ask you some question. There are some lawyers here who were lawyers in India. They studied in India, they became lawyers in India, and they came here and they became lawyers in America. And under the Advocates Act, as far as I know, you had to be you have to be an Indian citizen to be an advocate. And these people, when they come here and become a lawyer, they may have relinquished Indian citizenship and become US citizens. How those lawyers are treated?
I think, as you have rightly said, that probably the Advocate Act itself lays down the things, that once an Indian lawyer gives up the citizenship and takes up enrollment elsewhere becomes a foreign lawyer. So all the rights, what the foreign lawyers get through the BCI rules, all those people will become eligible to come to India and use those rights. But of course they do have an edge because they had the knowledge of Indian legal system as well as of their now country where they have graduated as a lawyer. So this is going to be beneficial or more kin to them because in fact in our last part of the leg of this conference, we have shortlisted very few people who have actually traveled their journey from India to US. So those people will be asking them in the end of the conference, they'll be coming up to share their viewpoints as well. So I'm sure more answers will be coming out of that as well. Thank you.
Thank you.
The other observation that might be worth making to Rakesh's point here was that, you start with namaste, then you have a handshake, then you have an embrace. One of the questions that some of my colleagues have raised is whether or not the BCI at some point may liberalize the rules so that, like in the United States, I can be admitted to practice in New York State, I can be admitted to practice in California, I can be admitted to practice in a number of states, and doing so does not remove my status as a lawyer in the earlier jurisdiction, whether or not there will come a point that you can be both an Indian lawyer recognized by the Bar and the Advocates Act and be a US or a UK or other lawyer is unclear, but I think we need patience and time to see whether or not those things will eventually emerge. There is no professional reason. You've got the training in both systems, so there's no educational or professional reason. At this point, it is purely an economic protectionist issue. And whether or not the Indian and US markets will become close enough so that they embrace that concept, one doesn't know, but we hope so.
Thank you, Mr. Sharma, Mr. Rosenbaum, and Mr. Safer for this detailed and informative discussion on this topic. I will now request Mr. Rakesh Sharma to present Mr. Randhir Jaiswal with a memento. Mr. Jaiswal, if you can come on stage.
Thank you for your presentation.
Oh, yeah. Thank you.
You know exactly where we are. So I'm a champion of your mother.
Joe, if you can still be there. You can just wait. I now request Mr. Manish Kuladi to come forward and Mr. Rakesh Sharma to present him with his memento. I now request Mr. Rosenbaum to come forward to receive his memento from Mr. Rakesh Sharma. Last from this session, Mr. Safer. Thank you. So now we will take a break for coffee and networking session, and we'll resume the session after 15-20 minutes. Please feel free.